Consent is the soul of marriage. SC does well to allow unilateral, no fault divorce, but also to guard against the abuse of this by making it contingent on the apex court's case by case discretion. The name of the author is Mihira Sood, who is a lawyer and visiting professor at NLU Delhi. Earlier this week, the Supreme Court held in the case of Shilpa Sailesh versus Varun Srinivasan that under the Hindu Marriage Act, divorce can be granted by the top court in certain cases on the grounds of irretrievable breakdown of marriage, a demand that has been growing in society but is yet to see any recognition by the legislature. Under Section 13 of the Hindu Marriage Act, a marriage may be dissolved on grounds of adultery, cruelty, desertion, bigamy, rape, etc., often called fault based cases. These are where a divorce petition can be moved by either party without the consent of the other. No fault divorce could be sought only by mutual consent under Section 13b, where both parties agree to have the marriage dissolved. In such cases, the parties would ordinarily file a motion for divorce and then have to wait 6 months before the decree could be passed by court. The intent was to give a cooling off period and allow the couple time for reflection. Courts recognized, however, that in many cases, this mandatory waiting period only prolongs the misery of the couple and often delays or impedes a settlement. There was no provision for a no fault divorce that could be granted without mutual consent if one party simply wants out. Thus, SC was faced with two questions. First, whether it could dispense with the waiting period in mutual consent cases, and second, whether it could permit unilateral no fault divorce or irretrievable breakdown of marriage. Both these questions were answered in the affirmative. Under Article 142 of the Constitution, SC is empowered to pass any decree necessary for complete justice in any cause or matter pending before it. It is under this power that the question of granting such divorces was allowed. Irretrievable breakdown of marriage was considered by the Law Commission in 1974 and again in 1978 in its 71st report. The report noted that neither party need individually be at fault here. It may be the result of prolonged separation, personality clash, or incompatibility. Such marriages are merely a shell out of which the substance is gone. For such cases, the Commission recommended that the law be amended to provide for irretrievable breakdown of marriage as an additional ground of divorce. This recommendation was reiterated by the Law Commission in its 217th report. In 2010, the government introduced the Marriage Laws Amendment Bill 2010, which proposed to add irretrievable breakdown as a new ground for divorce in both the Hindu Marriage Act and the Special Marriage Act. After receiving suggestions from relevant stakeholders, the bill was amended and reintroduced as the Marriage Laws Amendment Bill 2013. Under this bill, the 6-month waiting period could be mutually waived by the parties and irretrievable breakdown was introduced as a separate ground, where either spouse could move for such a decree after 3 years of non-cohabitation. Additionally, a woman could oppose such a petition on grounds of financial hardship, in which case the court could, considering all the circumstances, either make satisfactory arrangements to eliminate the hardship or dismiss the petition. This bill was never passed. Concerns about the disadvantageous position of women were such divorces permitted have weighed both with women's rights experts as well as courts. In Sivasankaran versus Santhi Meenal 2021, SC considered the question of social acceptance and economic security of women were such divorce to be granted unilaterally. One has to understand that the liberal notion of marriage as a partnership of mutual consent, however desirable, is not yet the reality in much of the country, and its dissolution usually entails enormous social and economic hardship for women and children. While these concerns are valid, it's important to note that the court has not provided a carte blanche for husbands to desert their wives or leave them destitute. The judgment says that such divorces can be granted as a matter of judicial discretion by SC alone under Article 142. It cannot be claimed as a matter of right. In hearing such cases, the apex court will keep in mind the circumstances, background, financial arrangements, and other interests of the parties on a case to case basis and pass appropriate orders. With these protections, this is a welcome decision, not just for the personal happiness of the parties, but also because it is only when divorce is normalized that we can eliminate the social stigma that still comes with it and ensure greater agency for women in matrimonial affairs. There may be many more women who would want such an option provided that their own and their children's economic security is not at risk. Just as the law needs to make getting married easier for people who want it, so it should be for getting divorced. At the heart of both is the idea of consent, an idea that needs to be given its rightful place at the core of matrimonial law.